attorneys have 10 days to appeal the sentence, and they're also preparing to appeal his conviction. So let's bring criminal defense attorney David Wolfe back into this conversation. I'm wondering, one of the big conversations yesterday when this was over was that 30 to 60 years just wasn't enough. You're talking about 10 kids over a 15-year period, and some people are saying even though it is a life sentence for him, don't those victims deserve to see a harsher sentence? And isn't this sending a message to other people when you give a sentence like this for crimes like this? What do you say to that?
Well, just like you said, I mean, I'm not a big fan of the sending a message aspect of a sentence and telling a jury that they can send a message during closing argument, because the questions really at issue are what happened and have they proven beyond a reasonable doubt somebody's guilt. But with regard to the 30 years, that is a life sentence. When it's 30 to 60, you have to serve the 30, and then it's called an indeterminate sentence. Between the 30 and the 60, you get the parole board has the opportunity in most states to determine whether or not you should be released. But just so you know, Sandusky's not going to be released, and he likely will die in prison. The oldest federal prisoner today in prison is 92 years old. Mm-hmm. That means everybody under that age, seems to me, has either, well, has died in prison or is still there. So,
based on the crimes that he committed, though, do you foresee any opportunity that a parole board would ever give him the green light to be paroled?
Well, you mean at age 98?
Yeah.
I don't know. There was a fella, a Hindu priest, who was released at 108 years of age after murdering 4 people. So I guess it is a possibility, but the likelihood of that are at the extreme, and Jerry Sandusky will die in prison unless his case is reversed.
Do you think there's any chance his case could be reversed?
Well, whether or not his case is reversed doesn't deal necessarily with whether or not he did the things they alleged that he did or that he's been convicted of. It goes more to, I think, are there technical issues, are there legal issues that didn't give him a fair trial, and as a result, he's entitled to be tried again.
Yeah, but I mean, people are saying that there's a solid argument for appeal in that maybe they were denied so many requests for an extension and that they didn't get it. But listen to what the prosecutor had to say about that argument.
I understand that a person in his position feels they must devote a certain amount of time to the media, but he might have spent it preparing. I congratulate him on his occasional forays into proximity reality.
Ouch. Okay, basically what he's saying is, hey, listen, you had appropriate time to prepare. You just spent a good chunk of it talking to the media and letting your client talk to the media, because we know that Jerry Sandusky did several interviews prior to this trial coming up, and he's saying they could have spent that time preparing for their case rather than, you know, trying to orchestrate these interviews. Is that fair to say?
Absolutely not. That's a bit presumptuous of the prosecutor to say that. 4 months to defend at the very least 10 separate acts of misconduct is ridiculous. The fastest trial I ever participated in was the Ray Lewis murder trial here in Atlanta, where he was arrested Super Bowl, the day after Super Bowl Sunday in February, and we went to trial in May. We were fortunate to have acquitted everybody, but we had one murder to address. These allegations that didn't come to light for so many years have to be invested individually, and they have to be investigated at foreign sites. They have to see what was said before, what was said after. You know, there are so many things, scientific evidence, what in fact was told to Penn State's folks, and those sorts of things, to really see if the facts that are coming out today, 15 to 17 years later, actually deal with what happened when the conduct, which hideous as it was, actually occurred.
Okay, so let me ask you this. We just have a couple of minutes, but A, who will decide whether an appeal is warranted, and B, how do they make that determination? Do they do it just looking at the argument being made that they didn't have enough time to prepare, or do they look at that in conjunction with all of the evidence that was at trial and determine things could have been different otherwise, or, you know what, there's so much evidence, this wouldn't have made a difference?
Right. It's generally a two-pronged test. The first test is, was there error?
Okay.
Okay? Did they send them to trial too quickly? And then the second question becomes, if in fact you clear that hurdle, was there a detrimental effect on the trial? You can have what is called harmless error if you can't demonstrate that the error actually would have resulted in a different outcome.
Okay, interesting. David Wolfe, thank you so much for explaining all of that to us as we watch whatever's going to be coming up from this one from now on.
Thank you.
All right, let's